So let us start with disqualifications for appointment of director. As I told you, the act is not requesting the director should be so and so person, such a person, etc. etc. But there should not be any disqualification for a director to be appointed. Disqualification means whether to check, it's a test check like whether this person is eligible or not for the appointment. If that person is of unsound minded and as so declared by the competent court, he cannot be a director of any company. If that is he's a person undischarged insolvent, probably some proceedings might be going and he's still not discharged as an insolvent, undischarged. Some adjudication is still pending. See, undischarged insolvent means adjudication over. Here, adjudication is pending. In that case, is called as adjudicated as an insolvent. He is convicted by the court of any offense, whether of moral turpitude or whatever it is, and sentenced to imprisonment for not less than 6 months, and a period of 5 years has not elapsed. He is being convicted and sentenced to imprisonment for not less than 6 months, which means ஒரு 6 மாசம் அவருக்கு ஜெயில போட்டிருக்காங்க and ஜெயில போட்டு 5 வருஷம் முடியல. See, 5 years has not elapsed from the period of from the date of expiry of the sentence. If a person has been convicted of any offense and sentenced for imprisonment for 7 years or more, he shall not be eligible to be director in any company at all. Please make a note of this provision. It talks about the imprisonment where up to 6 months means okay for a period of 7 years. For 7 years imprisonment now. Sorry, 6 months or more imprisonment இருந்திருக்காரு. அப்போ 5 years முடிஞ்சிருக்குன்னா டைரக்டரா இருக்கலாம். But imprisonment 7 years மேல போயிருக்குன்னா definitely he cannot be a director at all. And is there any order for disqualifying has been passed with the court or tribunal or any order is in force? He has not paid the call money. பாருங்க எவ்வளவு சில்லியா இருக்கு. ஒரு கம்பெனியோட டைரக்டரா வந்து ஷேர்ஸ் வச்சுட்டு அவரே கால் பண்ணி பே பண்ணலனா whether alone or directly with others and 6 months have lapsed na he can be a director, not elapsed na no. And he has been convicted of the offense dealing with related party transactions. Probably you might be aware of arm's length transaction. Arm's length transaction maintain பண்ணனும். Arm's length transaction maintain பண்ணல and especially related party இருந்தா arm's length transaction maintain பண்ணலனா he will be convicted with the offense in the last preceding 5 years and he has not obtained the DIN number. Probably you might be knowing the importance of DIN now. If that person has not obtained a DIN number, then he cannot be a director at all. And the private company might be by articles, they may provide some disqualification. Yes, it's open for the companies to provide any disqualifications because he is the person who is going to take care of the company. And the disqualifications referred with respect to D, E, and G shall continue even if the appeal or petition has been filed with respect to imprisonment or with respect to courts or tribunals order or with respect to conviction with related party transactions. Even if the appeal or petition is pending, he can never be a director. Vacation of office of a director. If a person wants to vacate, when he will vacate means very simple. ஏதாவது disqualification வந்திருக்குன்னா ரொம்ப important பாருங்க second pointல at least 4 board meetings should be held and he is absent for all the meetings of the board with or without seeking, whether leave கேட்டு leave போடுறாரோ இல்ல leave கேட்காம leave போடுறாரோ, he is absent for the board meetings for all the meetings. Now definitely he cannot be a director. And if he contravenes the provisions of the section 184, this is with respect to entering contracts and arrangements, whether he may be directly or indirectly interested, and discloses his interest whether directly in contravention of this provision 184 and uh, by court's order or tribunal he has been disqualified. He is convicted by a court of any offense whether involving moral turpitude and imprisoned for not less than 6 months. இப்பதானே நம்ம பார்த்தோம் அது. Provided he shall not be vacated by the director in case of orders for 30 days from the date of conviction on order of disqualification, or where an appeal or petition is preferred within 30 days now against consulting in sentence order, then until the expiry of 7 days, probably the appeal or petition may be disposed of at the period. Or if any further appeal or petition is preferred, order or sentence within 7 days, so it is to be pending. He is removed in pursuance of the provisions of the Act. or he has been appointed as director by virtue of any holding any office or other employment in case of holding subsidiary or associate company, and he breaches the limits of maximum directorship allowed. Breaches the limits of maximum directorship allowed. இவ்வளோ நம்பர் ஆஃப் கம்பெனிஸில் தான் டேரக்டராக இருக்கணும்னு இருக்கு. இதை மீறி போனான்னா டெஃபினெட்லி வில் பி டிஸ்குவாலிஃபைட். Obviously, a private company can have, in addition to the above prescribed in the articles, where all the directors vacate their office under any of the disqualification. நீங்களே நினைச்சு பாருங்க, a company cannot operate without the individuals working as directors. Then in that case, the central government shall appoint the required number of directors who will be holding office till the directors are appointed by the company in the general meeting. So annual general meeting la directors appoint பண்றதுக்கு central government may be appointing the required number of directors. So until then, those officials will be holding the directorship and the company will be led by those directors. If a person functions as a director, even when he knows that the office of the director held by him has become vacant, account of any of the disqualification, அவருக்கே நல்லா தெரியுது நான் இந்த கேஸ்ல டிஸ்குவாலிஃபை ஆயிருக்கேன்னு. டிஸ்குவாலிஃபை ஆன பிறகு அவர் ஒரு கம்பெனில டைரக்டரா இருந்தாருன்னா he will be punishable with imprisonment which may extend to 1 year or with fine which shall not be less than 1 lakh which may extend to 5 lakhs or both also. So this is a special heading, I would say. I would like to continue with resignation of a director, where how a director can resign. He may resign by giving a notice in writing, his resignation letter, right? Within 30 days from the date of resignation, he may forward to the registrar a company of the register a copy of the resignation along with the reasons in DIR 11. Okay, so DIR 11 is the form. In case the director is a foreign director, he may authorize in writing by a practicing chartered accountant or cost accountant or company secretary in practice, and other resident director also may be in signing the form DIR 11 and file the same on behalf, intimating the reasons for the resignation. And the board, on receipt of such notice, shall take notice of the same. இந்த மாதிரி நான் ரிசைன் பண்றேன், மேபி சம் பர்சனல் கமிட்மெண்ட் ஆர் வாட் எவர் த ரீசன் மேபி ரிசைன் பண்ணேன்னு சொன்னா யாருக்கு இவர் ரெப்ரசென்ட் பண்றாரு? கம்பெனிக்கு சொல்றாரா? கம்பெனியோட போர்ட் ஆஃப் டைரக்டர்ஸ்க்கு சொல்றாரு. கம்பெனி இஸ் கம்ப்ளீட்லி ரெட் பை த போர்ட் ஆஃப் டைரக்டர்ஸ், ஸோ ஹி வில் பி addressing to the board of directors only. Board of directors, இவரும் one of the person இருப்பாரு, but still even the board of directors, the collective noun, were representing the complete board of directors. Then accordingly, the company will be sending the intimation to the register in DIR 12 within 30 days. Sorry, not 30 days, 1 month from the date of receipt of such notice. And also it will be posted in the website of the company. And this fact of resignation, the why he resigned. See, resignation is not a small thing, right? ஒரு டைரக்டர் வந்து ஒரு கம்பெனியை விட்டு வெளியில போறேன்னா on what basis he is leaving the companyங்கிறது கிளியரா தெரியணும். So that should be included in the director's report immediately following the general meeting with the company. And the resignation may take place from the date on which the notice is received. எந்த டேட்ல இருந்து நோட்டீஸ் ரிசீவ் பண்ணிருக்காங்களோ அந்த டேட்டோ, இல்லைன்னா டைரக்டர் வந்து அந்த நோட்டீஸ்லேயே ஒரு டேட்டை ஸ்பெசிஃபை பண்ணிருப்பாங்க, whichever is later may be taken into account. And who has resigned shall be liable even after his resignation for the offences occurred during his tenure, which is a very important point in case of exam point of view. If any director is there or was there and அவரோட tenure, during his tenure, any liability has been taken by the director, now even after his resignation, definitely he will be liable. நம்ம எவ்வளோ கேசஸ் பார்க்கும்போது penal provisions பார்ப்போம், director or officer in default will be liable னு பார்த்துட்டு இருப்போம். இப்போதான் அந்த டைரக்டர் வந்து கிளம்பி போயிட்டாரு, ரிசைன் பண்ணிட்டாரு, இவருக்கு liability இல்லைன்னு சொல்ல முடியாது. அவர் டென்யூர்ல இருக்கும்போது, அவர் அந்த கம்பெனில டைரக்டரா இருக்கும்போது என்னென்ன liability incur ஆகுதோ as a director, even though he resigns from his directorship, still he will be liable. ரொம்ப பியூட்டிஃபுல்லான பாயிண்ட். Where all the directors resign from their office, then obviously central government may be appointing the required number of directors, and till the directors are appointed in the annual general meeting, they'll be taking care of, right? Fine. Removal of directors.